How to get a first class on your criminal law exams or courseworks. I'm Nini. I'm founder of StudyCrowd AI, previously known as Simple Studying. I have LLB and LLM degrees from City University of London. I've got high 2-1 and first class grades in my assessments at law school. Then I founded StudyCrowd AI to help law students get high grades, just like I did. We're building AI-powered platform for university students. We help UK and US university students to get high grades with tutoring and career mentoring, as well as personalized, simple study materials. Why you should trust us. We have over 25,000 registered customers already on our platform for UK legal education. That's like 25% of total law students in the UK. 90% of our regular customers for law reported to have got a first class after getting our premium subscription and regularly studying with our premium subscription, as well as 6 hours of tutoring sessions for each module. That's the perfect package. You can get premium subscription plus 6 hours of tutoring if you want to maximize your chances of getting a first class. So here are the topics that you need to revise. In an exam on criminal law, you'll most likely have a choice of questions. So for example, you could get 6 questions and you can select 3 out of 6. So this kind of exam style allows you to do selective studying, so you don't need to revise and practice for every single topic that was covered on your course, but you can select just the topics that you are more familiar with, you feel more comfortable with, and you feel more confident answering questions about those topics. I suggest that you choose these topics: non-fatal offences, homicide offences, property offences, and sexual offences. We have really good sample answers that you can find on our platform for each of these topics. So definitely go to studycrowd.ai, search for criminal law, and under model essays, you will find sample answers about these topics, which is like high to 1 first class level. So you can understand how you're supposed to answer problem and essay questions about these topics. Well, you need to make sure that you understand how to do the IRAC structure correctly. Obviously, you've heard about it, but one thing is to know theoretically, and the other thing is to have the ability to actually implement it when you write answers to problem and essay questions. First of all, you need to start with stating what is the legal issue. The legal issue is not repeating the facts of the case. No, that's not legal issue. For example, legal issue would be whether or not the actus reus of, let's say, theft is present. That's a legal issue. However, repeating the facts of the case is not, to make sure that you state the legal issue that you are addressing. Then identify the relevant law. So if we go back to the previous example about theft, you need to say which section of which statute is actus reus of theft set out, and identify the relevant cases, talk about the principles, but do not just summarize all the cases, the facts and principles. Just mention what is relevant for the problem question that they gave you. If something is not relevant, don't mention it. Only mention relevant facts of cases and relevant principles that leads to an argument. Don't just say things for the sake of saying it. You need to create arguments. You are a future lawyer, and lawyers are supposed to defend their clients and are supposed to make arguments to defend their clients. So accordingly, you're supposed to make arguments here rather than simply just describe the law, right? And finally, you need to have conclusions and multiple mini conclusions. So if it's a problem question, after discussion of each legal issue, you would have like a mini conclusion that you would need to put after every single legal issue. So critical analysis would be the following. First, discuss the law, then apply and then analyze. Let's see offences against a person. there are multiple offences that fit under this category. First one is assault. The actus reus, the physical element of assault, is defendant causing the victim to apprehend immediate unlawful personal violence. So basically just scaring someone and making them think that you would be violent. You would like punch them or something. Even shouting at someone very aggressively could amount to actus reus. And mens rea would be intentional recklessness. So even recklessness, being careless, would amount to assault. Battery, on the other hand, requires physical touch. So punching could be battery. Infliction of unlawful personal force. So there must be some force inflicted by one person upon another. And the mens rea similarly is intentional recklessness as to the infliction of unlawful personal force. Then you have IBH and GBH, which is similar but a bit more serious result. So by this I mean that you need to have assault and battery as a base offence. But the result that happened after the commission of these offences is more serious than assault or battery. For example, a person broke something, suffered a serious injury as a result of assault or battery. GBH, on the other hand, is grievous, serious bodily harm, which is set out in Offences Against a Person Act 1861, Section 20 and Section 18, whereas ABH is set out in Section 47. When you answer problem and essay questions about these offences, make sure that you cite the relevant sections. If you are writing a coursework, you would probably need to do footnotes, unless your professor has advised you to do it otherwise. But if it's an exam, a timed exam where you have very limited times to how much you can spend on writing, maybe they don't need footnotes, and maybe they'll tell you that you can just like put citations in brackets at the end of the sentence. So in that case, you will put like something like this: Offences Against the Person Act 1861, Section 47, just in brackets after the sentence. But if they ask you for proper citations, then definitely do footnotes, just like scholar referencing requires you to do. GBH, by contrast, compared to ABH, is more serious injury. When someone suffers more serious injury, it requires wounding, breaking of the skin. Serious wound also includes broken bones or serious psychiatric injury. So first, you need to discuss the actus reus, the physical element of the crime, and state what is the actus reus, citing the relevant statute or case, and then apply it to the facts. Secondly, discuss what is mens rea, state the mental element of the crime by application of the relevant statute and case law. And thirdly, discuss all possible offences that may apply to the facts. And finally, discuss any available defences. So actus reus, mens rea, critical analysis, and defences. You need critical analysis at every single stage. So once you say what is actus reus, then apply it to the facts of the case, critically analyse, then move to mens rea, apply to the facts of the case, critically analyse. Make sure you discuss all possible outcomes from the case, and then finally move to defences. For certain crimes, there are specific defences just for that crime. For example, murder. Murder has specific defences that only applies to murder. However, there are general defences that applies to all crimes, except few exceptions. But most of the crimes, like insanity defence, for example, or automatism. So make sure that you're familiar with those general offences, general defences, and apply them whenever relevant. You don't need to discuss it if it's not relevant, but if it is relevant, definitely apply it. Now, let's talk about homicide offences, because this will most likely come up on your criminal law exam. Murder is the most serious homicide offence, which is unlawful killing with malice aforethought. Actus reus of murder is conduct that causes death of a person. So somebody has to die for the offence of murder to be committed. If there is no death, there is no murder. If it was like extremely serious injury, then you would look at GBH rather than murder, even if the person had intention to kill. So mens rea is intention to kill or cause GBH, grievous bodily harm. So somebody has to die, and the offender must have an intention to kill or cause the GBH. Then manslaughter. Manslaughter is when there is actus reus, but in case of involuntary manslaughter, there is no mens rea, and in case of voluntary manslaughter, there is mens rea, but one of the partial defences apply. So for voluntary manslaughter, you have the same actus reus as murder, but one of these partial defences apply: loss of self-control, diminished responsibility, and suicide pact. So loss of self-control cannot be from jealousy. So if a spouse murdered their spouse because they were unfaithful, that wouldn't be enough to qualify for loss of self-control partial defense. Diminished responsibility is when someone before diminished responsibility, just wanted to mention that for loss of self-control, it must be sudden loss of self-control because of some kind of triggering event. And diminished responsibility is when someone has a psychological condition and was not really realizing that he was killing someone. And suicide pact, when two people agreed that they would kill themselves and one of them didn't. Involuntary manslaughter is when there is no mens rea for murder. So actus reus is there, but the mens rea is not. So there are three kinds of involuntary manslaughter: unlawful act manslaughter, gross negligence manslaughter, and reckless manslaughter. Unlawful act manslaughter would be something like killing someone in an accident because of negligent driving, which is an unlawful act. Negligent driving is an unlawful act, which resulted in someone's death. That would be unlawful act manslaughter. Gross negligence manslaughter would be cases like medical negligence, when a doctor committed some kind of negligence act, and as a result of that, the patient dies. And reckless manslaughter is when someone did something reckless, and without them realizing it, as a result, someone died. Property offences. There are three main types of property offences. One is theft. Theft Act 1961, Section 1, dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it, which is the definition of theft. So it must be dishonesty, and for dishonesty there is a test that you need to apply, and there is a case that you need to cite. You need to prove dishonesty. Second, taking someone else's property. Appropriation means taking someone else's property. And finally, the intention to never return it. So taking someone else's property with the intention to never return it, and by being dishonest, to just translate it in simple words. Secondly, robbery. What is the difference between theft and robbery? Robbery, in addition to stealing, requires force. so usage of force or causing fear of being subjected to force. And finally, burglary, which is set out in Theft Act 1968, Section 9. It requires trespassing, plus intention or recklessness as to the trespass, and intention to commit the ulterior offence, such as stealing or causing GBH, grievous bodily harm. So ulterior offence can be theft, attempted theft, or GBH. So there must be trespassing. Someone else has to enter the property without the owner's permission, with the intentional recklessness to trespass. And then they must have intention to steal or attempt to steal or commit grievous bodily harm. That's burglary. Example question that you may get on an exam on homicide offences. A man intends to set fire to his own house for insurance money. 2 people died as a result of the fire. He did not want to kill those people. He thought there was nobody around. Which homicide offence will be the most appropriate in this case? So you would start with murder, the most serious one, and then discuss the possibility of voluntary or involuntary manslaughter, and obviously reason it. First, discuss what is this actus reus and mens rea of murder. Here, the man committed the actus reus of murder. Someone died, right? So the death, unlawful killing, is actus reus of murder. However, he did not intend to kill. Therefore, he did not intend to kill or cause GBH, right? So therefore, there would not be mens rea of murder. Hence, there would not be voluntary manslaughter either, because for voluntary manslaughter, you need both actus reus and mens rea of murder. But involuntary manslaughter, yes, that would be the most relevant one here. But there are 3 types of involuntary manslaughter, so which one would it be? In particular, here, I believe it would be more either unlawful act manslaughter or reckless manslaughter. Because, obviously, starting a fire is legal and it would be unlawful act. And recklessness is also permissible here. So either of these 2, you would discuss possibility of both and apply the relevant cases. Apply to the facts all the relevant cases for unlawful act manslaughter and reckless manslaughter that applies to this scenario should be analysed here. And finally, you need a conclusion. Unlawful act manslaughter, unlawful act plus objectively dangerous plus causing death. These are the ingredients for unlawful act manslaughter. Here, unlawful act was arson, starting the fire. Setting his house on fire was dangerous, obviously, which caused death. And the relevant cases that I suggest you apply in a scenario like this is Lem 1967 and Church 1965. If you go to studycrowd.ai, you can just search these cases and you will find case summaries. And obviously, you should also go to notes, criminal law, and then notes. And under notes, you will find homicide offences, murder, voluntary manslaughter, involuntary manslaughter, everything described in detail, everything you need to know with all its cases. And you should read the notes. And if you want to look into these case summaries in more detail, then just search the case on the platform. And the case summaries we have on the platform is more detailed than the case summaries we have in the notes. The notes are more like simplified, condensed, shortened version of the material, whereas the case summaries we have on the platform is more in-depth if you want to do more like detailed research. Here are the first class tips if you want to get a high grade. Be creative with your arguments, something that was not said in the class. So if you can show that you've done extra research, extra studying, something that was not mentioned in the class, and your arguments are really creative, that would be a way to gain few extra points. Excellent understanding of the law and impressive critical analysis. Like that's one of the criteria for marking. You need to understand the law very well, not make any mistakes in understanding the law, and your critical analysis when you apply the law to the facts of the case and make arguments, that must be excellent. A very creative, very nice critical analysis covering both sides of the argument. So to what extent, in this case, unlawful act manslaughter charge would succeed? What are the chances? Like by exploring all kinds of outcomes, all kinds of arguments, you would gain extra points. Correct or scholar referencing. This is easy points, and I suggest that you look at my video about scholar referencing. If you go to YouTube, find our channel Common Law Simplified, or just go to studycrowd.ai, scroll all the way down, and on the footer you will find all our socials, and on our YouTube channel we have a video about referencing or scholar referencing, which is 15 minutes long, very popular. A lot of students are watching it. I very simply explained how to do scholar referencing, and I suggest that you watch that video and make sure that you follow it. If you make mistakes in your scholar referencing, you will lose marks, and you don't want to do that because it's easy marks that you want to keep. Covering all the relevant legal issues that was covered in the lectures. So your lectures are very important because it shows which cases should be mentioned in your answer. There are many cases, many possible cases that you could cite, but the lecture specifies certain cases that they want you to mention. And if you don't mention those cases that your professor wants you to, you will lose marks. So make sure that you mention everything that your professor wants to according to the lectures, plus all the additional stuff. You definitely look at our study materials. Most likely all the cases that were mentioned on your lecture is very clearly and in a simple manner explained on our notes. So make sure that you read our notes plus your lectures. That would be all. And use it when you answer your problem and essay questions in criminal law. And in-depth arguments. I see many students lose marks because their arguments are superficial. So make sure that you explore the arguments in depth rather than like superficial arguments by just like saying one sentence about a case or a legal issue. It has to be really, really in-depth arguments if you want to get a first class. So go to studycrowd.ai, study using our materials on criminal law or any other subject that you have to pass. Receive one-to-one tutoring. This is extremely important. If you just click on tutoring on the platform, follow the instructions. The revision notes, the revision classes like this one can be booked from there. And one-to-one tutoring, which is extremely recommended, very important for you to learn how to answer problem and essay questions. You can book it from there. And obviously you should attend the free revision classes like this one. On our YouTube channel, you will see all the revision classes that we've had ever. So definitely subscribe to our YouTube channel and look at our free revision classes. But free revision classes are not enough for you to get a first class. Neither are the study materials. They are amazing tools and will definitely help you to improve your grades. But if you are serious about getting a high 2-1, a first class, you need one-to-one tutoring. We've tested a lot of kind of simplified study materials and revision classes like this one, but nothing can replace one-to-one tutoring with an expert tutor who has been through it all and have already got high 2-1 and first class grades in their own degree as well as with their students, and will be able to guide you in detail for your assignments. Thank you very much and hope to see you soon. Bye.